Red and blue lights fill your mirror. Your heart rate spikes before you've even pulled over. The officer walks up, takes your license and registration, and then says something you didn't expect. Can you unlock your phone for me? In that split second, most people do something that could come back to hurt them badly. They just hand it over. No hesitation, no questions. Because when a police officer asks you for something, your brain doesn't process it as a request. It processes it as an order. And that one moment of confusion is exactly why this topic matters so much. Here's the first thing that might surprise you. In the United States, a police officer asking you to unlock your phone during a traffic stop is, in almost every situation, not a lawful command. It's a request, and requests can be declined, but almost nobody declines them because nobody explains the difference in the moment it actually matters. So why does this happen so often? Why do so many people unlock their phones the second an officer asks? Part of it is psychology. Authority creates pressure. When someone in uniform asks you a question during a stressful encounter, compliance feels like the safest option, even when it isn't legally required. But there's a deeper reason too, one we're going to get into a little later, and it has to do with how differently the law treats your car compared to your phone. Let's set the scene properly. You're pulled over for something minor, maybe a taillight, maybe rolling through a stop sign. The officer takes your documents, walks back to the cruiser, and returns a few minutes later. Then comes the question about your phone. Maybe they say they're investigating something. Maybe they just say it casually, like it's routine paperwork. Either way, most drivers freeze for a second and then comply, because they assume refusing will make things worse. This is where the story gets interesting, because the law here is built on a foundation that most people have never actually read. It goes back to the Fourth Amendment of the United States Constitution, which protects people from unreasonable searches and seizures. That single sentence, written over 2 centuries ago, is doing an enormous amount of work in the modern world of smartphones. Now here's a twist that trips a lot of people up. Courts have ruled repeatedly that your vehicle receives less Fourth Amendment protection than your home. This is sometimes called the automobile exception, and it traces back to a Supreme Court case called Carroll versus United States from 1925. Because cars are mobile and can be driven away quickly, courts have allowed officers more flexibility to search a vehicle without a warrant under certain circumstances, especially if they have probable cause that it contains evidence of a crime. So if cars get less protection, what about the phone sitting in your cup holder? This is exactly the question that used to confuse lower courts across the country, until the Supreme Court stepped in and settled it in a landmark decision that changed everything. That case is Riley versus California, decided in 2014. And what the court said in that ruling is honestly one of the most important digital privacy decisions in American history. The justices ruled unanimously that police generally cannot search the digital contents of a cell phone during an arrest without a warrant. The court reasoned that modern smartphones are fundamentally different from anything police might have found in someone's pocket 100 years ago. They contain years of photos, messages, browsing history, financial records, medical information, location data, essentially a window into a person's entire life. Chief Justice John Roberts wrote that these devices hold the privacies of life, and that reasoning became the backbone of digital privacy law going forward. So think about what that means. A police officer might be allowed to search your car under certain conditions without asking your permission. But your phone? That's an entirely different category. Even if you've just been arrested, officers generally need a warrant to dig through the data inside it. And if a warrant is required even after an arrest, that tells you something important about a routine traffic stop where there hasn't even been an arrest at all. Now here's where a lot of confusion starts. Some people hear this and think it means police can never ask about your phone. That's not accurate either. Officers can ask you questions. They can ask you to hand over your phone. They can even ask for your passcode. Asking is not illegal. What matters is what happens next, and that depends entirely on whether you agree. This is the misconception that trips up more people than almost anything else in these encounters. Many drivers believe that if a police officer asks for something, refusing is illegal or will automatically be treated as suspicious. But asking for consent and having the legal authority to compel you are two completely different things. If you say no to unlocking your phone and there is no warrant and no valid exception that applies, that refusal itself is not a crime. This is where consent becomes the center of the entire story. If you unlock your phone because an officer asked you to, and you agreed, courts often treat that as valid consent, meaning you voluntarily gave up a layer of your constitutional protection. Once that happens, anything found afterward may be used against you. And arguing later that you didn't fully understand your rights becomes a much harder legal battle to win. This is why so many defense attorneys stress one simple idea. You are allowed to say something like, "I don't consent to a search of my phone." Saying that calmly is not obstruction. It is not resisting. It is not illegal. It is simply preserving a right that already belongs to you under the Constitution. But here's where things get more layered, because unlocking a phone isn't only a Fourth Amendment issue. There's another constitutional protection running quietly underneath all of this, and it comes from the Fifth Amendment, the right against self-incrimination. This is where an important legal distinction shows up, one that has actually divided courts across different states. There is a meaningful difference between being asked to provide a passcode, which is something you know, stored only in your memory, and being asked to provide a fingerprint or face scan, which is something you are, a physical characteristic. Several courts have wrestled with whether forcing someone to reveal a memorized passcode violates the Fifth Amendment, since it could be considered compelled testimonial evidence. Biometric unlocking, like a fingerprint or facial recognition, has sometimes been treated differently by courts, with some rulings allowing law enforcement to compel biometric unlocking under specific legal processes, since courts have debated whether it's more like a physical characteristic rather than spoken testimony. This is genuinely one of the most actively contested areas in modern criminal law, and rulings differ from state to state and circuit to circuit. Some courts have sided with strong Fifth Amendment protections for passcodes, and others have allowed narrow exceptions. This isn't settled uniformly nationwide, which is exactly why this topic isn't as simple as a yes or no answer. It depends on your jurisdiction, the specific facts of the case, and how courts in that region have interpreted these constitutional protections. Now let's rewind to that traffic stop, because there's a phrase attorneys hear constantly from clients after the fact. "I thought I had to." That single sentence has shaped the outcome of countless cases. People believe cooperation equals safety. And in terms of personal safety during the stop, staying calm and polite absolutely matters. But cooperation and constitutional rights are not the same thing. You can be respectful, composed, and law abiding in your tone while still declining a request that isn't legally required. Here's a practical distinction that helps clarify the confusion. If police have a valid search warrant specifically authorizing them to search the contents of your phone, that's a different situation entirely. And complying with a lawful warrant is not the same as consenting voluntarily. Similarly, if you're placed under arrest, different legal considerations can apply, and it's always wise to say clearly and respectfully that you wish to speak to an attorney before answering further questions or providing access to devices. But during a routine traffic stop, before any arrest, before any warrant, the situation is usually much simpler than people assume. An officer asking you to unlock your phone is typically asking for consent, and consent is optional. So, what should you actually do if this happens to you? Legal experts and civil liberties organizations generally suggest the same core approach. Remain calm. Keep your hands visible. Comply with lawful instructions like providing your license, registration, and insurance. But if you're asked to unlock your phone and you don't want to, You can say clearly and respectfully, "I do not consent to a search of my phone." You are not required to explain why. You are not required to raise your voice or argue. A single calm sentence is enough to preserve your position without escalating the interaction. Now, here's something that adds even more weight to this entire discussion. Once you unlock a phone and hand it over, officers may not need to limit themselves only to what they originally said they were looking for. Depending on the situation, anything else visible or accessible on that unlocked device could potentially become relevant to the encounter. That's part of why this decision matters so much more than people initially assume. It isn't just about one folder or one app. It's about the entire digital footprint of your life sitting behind that screen. At this point, you might be wondering what happens if you refuse and the officer continues anyway. This is where documentation becomes critical. Many attorneys recommend that if you believe your rights were violated during any stop, the correct approach isn't to argue in the moment. It's to comply with lawful instructions, avoid physical resistance, remain respectful, and challenge any improper search later through an attorney, potentially through a motion to suppress evidence in court if a search was conducted unlawfully. Physical resistance during a stop can create serious legal and safety consequences for you, regardless of whether the search itself was valid. So the safest path is always verbal assertion of rights, not physical confrontation. This brings us to something people rarely think about until they're already in the situation: the psychology of the moment itself. Traffic stops are designed, whether intentionally or not, to create urgency, lights flashing, an authority figure approaching your window, a natural instinct to avoid conflict. That environment is precisely why knowing your rights before you're in that moment matters so much. In the actual instant it's happening, adrenaline narrows your thinking. But if you already know, calmly and clearly, that refusing to unlock your phone is not illegal, that knowledge becomes something you can access even under pressure. And this is really the heart of the entire lesson. The Fourth Amendment protects you from unreasonable searches. The Fifth Amendment protects you from being forced to testify against yourself. Together, these two protections form a legal shield around the most personal device most of us carry every single day. But that shield only works if you know it exists, and if you're willing to use your voice, calmly and respectfully, in the moment it matters most. So the next time you see those lights in your mirror, you'll know something most drivers don't. A request is not a command. Consent is not the same as obligation. And staying calm while respectfully declining is not defiance, it's simply exercising a right that's been part of American law for over 2 centuries, just applied to a device the founders could never have imagined. If this kind of legal knowledge is the sort of thing you want more of, there's another video on this channel that goes even deeper into what actually happens if police search your car without a warrant, and the surprising exceptions that could apply even when you say no. Go check that one out next, because once you understand how these two situations connect, you'll walk into any encounter with law enforcement knowing exactly where your rights begin and where they end.